So, in this video, we will discuss the very application of those provisions underlined under Article 15 of the Constitution, that is relating to those prohibitions regarding discrimination. So, in that context, we will first examine what exactly discrimination means and how it was pronounced in the important leading case that we will discuss, John Bhalamatham versus Union of India in 2003. The Supreme Court expressed that the discrimination forbidden by Article 15 is only such discrimination as is based entirely on the ground that a person belongs to a particular religion. The said right conferred by Clause 1 of Article 15 being only on a citizen. The same is an individual right by way of guarantee which may not be subjected to discrimination in the matter of rights, privileges, and immunities pertaining to him as a citizen. In other words, the right conferred by Article 15 is personal, a statute which restricts a right of a class of citizens in the matter of testamentary disposition who may belong to a particular religion would therefore not attract the very worth of Clause 1 of the Article 15 of the Constitution of India, as it was pronounced by our Supreme Court in this very leading case. And now we will go to what exactly backward class and what are the very ingredients of backwardness, and that relating to backward class as it was decided in the leading case Anil versus Dean Government Medical College Nagpur in 1985 by the Bombay High Court. So there they defined it as Clause 4 of Article 15 may, at the first sight, appear to be a blanket provision protecting any kind of beneficial discrimination in the nature of special provision for the benefit of the classes mentioned therein. However, apart from questions as to when a particular class can be legitimately regarded as backward class, discriminatory provisions of such a nature may be struck down as unreasonable in the circumstances. This is on the basis that the general right of equality guaranteed by Article 14 would override the special provisions under Article 15, Clause 4 in such circumstances. Hence, reservation of an excessively high percentage of seats in technical institutions for each classes would be void. In fact, ordinarily speaking, reservation in excess of 50% of available seats may not be offered. The reservation in this leading case also lead us to discuss another important leading case relating to reservation as to backward classes, and that is K.C. Basant Kumar versus State of Karnataka in 1985. The Supreme Court expressed that in making reservation by executive order by virtue of Article 15 Clause 4, the state has to take care that it is not unduly wide. Apart from scheduled caste, scheduled tribes, the other classes eligible for reservation, if made by the state, is the category of socially and educationally backward classes of citizens. And now we'll go to the very provisions and decisions relating to area wise reservation, and in that connection we will discuss an important leading case, Devarkonda Rajesh Babu versus Nizam Institute of Medical Sciences in 1998. The Andhra Pradesh High Court expressed that area-wise reservation as provided under Article 371D prevails over reservation under Article 15 Clause 4, as it was decided in this very important leading case. And now we'll go to the very provision relating to vertical reservation, and as it was decided in the leading case, Public Service Commission Uttaranchal versus Mamata Bis in 2010 by the Supreme Court. And in that very important leading case, it was the principle that reserved category candidate getting appointed against non-reserved post will not be counted against reserved quota. It applies only to vertical reservation, but not to horizontal reservation for women and handicapped persons. And now we'll go to the next important area to which Article 15 is applied, and that is racial discrimination. And in that connection, we will discuss an important leading case decided by our Supreme Court, and that is Karma Dorji versus Union of India in 2017. The Supreme Court held that racial discrimination against persons of northeastern states should be stopped, and the apex court has directed the union government to constitute a committee for to ventilate such grievances and for proper redressal. And now we'll go to another area to which Article 15 would be applied, and that is discrimination on grounds of sex. And in relation to that, we would like to discuss a leading case, Kerala State Electricity Board versus Sinia Mole in 2008. The Kerala High Court made the observation that as it relates to the very question relating to reservation and any kind of discrimination on the ground of sex. So, in relation to that, we found that the very racial discrimination as related to Article 15, the very provision as regards to racial discrimination, as we found under this that it was pronounced by the Kerala High Court that racial discrimination against persons on the very grounds of sex, it is here the very exclusion of women, not exclusively based on sex but taking into consideration peculiar nature of duties to be performed by electricity workers is not violation of Article 15 of the Constitution as it was decided by the Kerala High Court in this leading case, Kerala State Electricity Board versus Sinia Mole in 2008. And now we'll go to the next one, and that is relating to women reservation in relation to the provisions of Article 15, and in relation to that we will discuss a leading case, that is Rajesh Kumar Gupta versus State of Uttar Pradesh, and it was a case of 2005 decided by our Supreme Court. So the very apex court expressed that reservation of 50% of posts in favor of female candidates is not arbitrary, as it was decided in this very particular leading case in relating to reservation for women and its relationship with Article 15 of the Constitution. Now we'll go to medical college reservation in relation to Article 15 as it was decided in the leading case Ajay Kumar versus State of Bihar in 1994 by our Supreme Court, where it was declared that reservation in medical colleges is permitted. And next one is that reservation in very particular specialization in medicine, and in relation to that Supreme Court expressed in the very leading case Faculty Association All India Institute of Medical Science Delhi versus Union of India in 2017. It held that the rule of reservation is not applicable for specialty and super specialty faculty posts in medicine. So, the very rule of reservation as per the provisions of Article 15 regarding discrimination as relates to that the very rule of reservation is not applicable for specialty and super specialty faculty post in medicine as it was decided by our Supreme Court in this leading case in 2017. And now we'll go to university wise reservation in relation with Article 15, and in relation to that we will discuss important leading case Mohanbir Singh Chawla versus Punjab University, and it was a case of 1997 decided by our apex court, and in particular it was expressed by the Supreme Court that university-wise preference is valid if it is reasonable. So domicile-wise preference is valid if it does not exceed reasonable limits, so also college-wise preference is bad as considering the very provisions of reservation as provided under Article 51 only to remove the very discrimination as it is prevailing among the socially educationally backward classes and also regarding the scheduled caste and scheduled tribe. So, university wise reservation, if made on the basis as college-wise reservation, then such preference is bad as it was declared by the apex court. But in case of university-wise preference, if it is found reasonable, then it is valid. So also, if the very university-wise reservation is based on domicile-wise preference, then also if it has certain reasonable limits, then that preference would be held valid. And lastly, we'll discuss the very relationship between Article 14, that is relating to right to equality, and its relation to Article 15, where there is prohibition of discrimination. And in relation to that, we will discuss the most important leading case, that is State of Sikkim versus Surendra Prasad Sharma in 1994. Supreme Court expressed that, in a sense, the general and abstract principles of equality laid down in Article 14 is spelled out for certain situations in greater detail in Article 15 and in some of the succeeding articles. But it should be noted that Article 15 is limited to citizens, while Article 14 extends to all persons. And secondly, Article 15 Clause 1 and Article 15 Clause 2 are both limited to discrimination on the grounds of religion, race, sex, place of birth, or any one of them. And thirdly, the article permits the state to make special provisions for women and children. And fourthly, the article also permits the state to make any special provisions for the following, such as the socially and educationally backward classes of citizens, so also for scheduled caste and scheduled tribes. So Article 14 prohibits the state from denying to any person equality before the law, as it is pronounced in this leading case that equality before the law as relating to Articles 15 Clause 1 and Article 16 Clause 2, which protect the citizens against discrimination. So, this leading case, State of Sikkim versus Surendra Prasad Sharma of 1994, as it was decided and declared by our Supreme Court, and such a precedent in the form of ratio decidendi established the very relationship between Article 14 in relation to Article 15. So, it must be followed by all the inferior courts in the judiciary in India. So also why the apex court in its own judgment as it was expressed the very provisions of Article 14 in relation to Article 15 of the Constitution of India.